The case is now being live streamed. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning is Justice James Milkey and Justice Dalila Wendland. We will be the panel for all 6 cases that we'll be hearing today. The first 3 matters are criminal or quasi-criminal matters with the Commonwealth as the plaintiff. We will take a break of about 15 minutes after the argument in the 3rd case and resume argument with the civil cases. We have 5 cases on the list this morning. 1 case has come off the list. Each side has 15 minutes to argue, and there is no rebuttal. The first case on our list this morning is case number 2019 P1553, the Commonwealth versus Paul St. Martin. As a reminder to counsel, this case is partially impounded, and Attorney Hirsch, you may begin.
Thank you. If it pleases the court, Mr. Chief Justice, David Hirsch representing Mr. St. Martin. Your Honors, we know that due process requires that commitment not occur absent serious difficulty in controlling sexual impulses. That's been stated over and over again in the Kansas versus Crane, in our own cases of Johnstone, Dutiel, Fay, and others. Yet in this case, the Commonwealth agrees that the evidence was insufficient to find that Mr. St. Martin had serious difficulty in controlling his behavior. Not only that, but Dr. Bruce Weir, the only one of the Commonwealth's expert who addressed the issue, specifically said, it's not a general lack of power to control his sexual interests. In my opinion, he is not controlling his sexual interests, but that's part of his deviant sexuality. This, Your Honors, should be dispositive. This is the key issue in this case, and there is just no evidence to support commitment under it.
Mr. Hirsch, if I can just interject on that point, the statute, as I read it, requires that the Commonwealth establish that the person suffers from a mental abnormality or personality disorder, which makes the person likely to engage in sexual offenses if not confined to a secure facility. And if I'm reading from transcript volume 3 at page 122, the expert opinion says, so it's my opinion that if he's not confined to a secure facility, Mr. St. Martin is likely to reoffend sexually. And yet you contend that that does not satisfy the statutory requirement. I'm puzzled.
Your Honor, that's because the requirements for commitment are greater than those merely stated in the statute. When this court considers sufficiency, it has to consider not only the language of the statute, but the judicial glosses on it. That's stated in Johnstone. And the judicial glosses on this one include that requirement of inability to control sexual impulses. So even if the person is considered likely to reoffend by the experts, that's not enough. Because if that individual can control those impulses and barely chooses not to, well, that's the difference between mere criminality and a condition making somebody liable to civil commitment.
The statute talks about impulse control in a different subsection. That is, I was reading from subsection 1. And yet you're saying that by under Johnstone, the cases have expanded the reach of I guess it's subsection, I can't remember, 3 or 4, expanded that across all requirements.
Well, Your Honor, it's a constitutional requirement under Crane and other cases. And yes, Johnstone did say you don't merely rely upon the statutory language. For instance, in Johnstone, the court, while acknowledging that the statute says nothing about the requirement that a qualified examiner find the individual sexually dangerous, imposed that requirement. Other requirements have been imposed, specifically in the Suave line of cases, which we're talking about right here. And if that's not met, the evidence is insufficient. Now, in terms of my sister's argument concerning the general lack of power to control being analogous to the Kansas versus Crane requirement, I agree. But the issue is that here, there has been no showing of a general inability to control either, general lack of power to control either. We have to look at the previous.
Attorney Hirsch, if I could interrupt. I thought the general lack of power to control fell under the definition of personality disorder. And as I understood your sister's argument, the theory pursuant to which the Commonwealth was seeking an SDP commitment was that Mr. St. Martin had a mental abnormality, not a personality disorder.
And again, we have to go beyond the statutory language and look at the constitutional requirements.
So you're saying that the Constitution requires that even if the government is going under the mental abnormality, they have to show a general lack of power to control?
Yes, they have to show a serious difficulty controlling. That's the language of Kansas versus Crane, which has been repeated time and time again in our courts. In fact, in the Dutil.
But let me just stop you there. So mental abnormality, though, is defined as a condition of a person that affects volitional capacity, such that it predisposes the person to commit the criminal sexual act. Why is that requirement that comes from substantive due process not met under that definition of mental abnormality?
Your Honor, I think we have to look at the statute in the light of the constitutional requirements.
Right, and so what I'm doing is asking you, why is the constitutional requirement from Kansas v. Crane not met by requiring a showing of mental abnormality, where showing mental abnormality requires that the defendant is unable, lacks the volitional capacity, and it predisposes him to commit the criminal sexual act?
Oh, it is. I'm not challenging the constitutionality of the statute.
Okay. Oh.
No, but I think the point that Judge Wendland is asking about isn't that requirement of lack of capacity to control subsumed in the definitional criteria of mental abnormality?
I wouldn't use the word subsumed there, Your Honor. It's a requirement of it. And when that requirement is not met, the evidence is insufficient. Otherwise,
well, that gets to be a little circular, because what we have is evidence from experts saying that he suffers from a mental abnormality as defined in the statute.
And if we leave it at that, Your Honor, we create a situation in which everybody is relying on everybody else. Especially, first, we're giving too much power to the qualified examiners who can, as shown by Dr. Bruce Weir's opinions and testimony in this case, we're giving an incentive to qualified examiners to replace the law with their own opinions.
So that it seems to me starts to shift the grounds of your argument from a claim regarding the sufficiency to one regarding the weight.
I don't believe so, Your Honor, because it's our argument that sufficiency requires an explicit finding that the person is unable to control the impulses. Now,
I understand, but if the definition of mental abnormality incorporates that element, then the opinion that he suffers from a mental abnormality as defined in the statute satisfies that requirement, and now you're challenging the legitimacy of that opinion.
I'm challenging, excuse me, please, Your Honor.
Yeah.
I'm challenging the sufficiency of the opinion. You need to do more than just say that something is that something exists. You have to provide, the expert has to provide at least the opinion that the component parts of it exist. Otherwise, the constitutional requirement becomes a nullity.
Can we? Else? Oh, sorry, go ahead, Judge Milkey.
Can we get into more about the specifics of this case? My understanding is that the mental abnormalities at issue here were pedophilia and some form of exhibitionism. That being the case, did the experts expound as to what they meant by those terms? Because focusing on pedophilia, there's the technical meaning within DSM-4 and now DSM-5. The SJC has said that we're not bound by those, but it's not clear to me sitting here right now what the expert meant when he or she used those terms in this case. Did it, to use the chief's term, subsume the lack of volition, or is it just that he was, for example, attracted to underage girls or prepubescent girls?
Well, Your Honor, it was certainly pointed out by the experts that he had acted on the pedophilia. That's obvious because he had offended against this young girl over a period of years.
No, but that may be because he was attracted to young girls and he chose to act on that as opposed to lack of volition. And your point, I take it, is that the constitutionality of a preemptive detention scheme depends on the lack of volition.
Correct. And that's what it says in Dutil, that where it rejects the defense's claim that the legislature by the statute intended to include people who choose to engage in inappropriate sexual conduct despite their ability to control their desires. The court said, this is a specious argument. That's not what the statute does. It requires the inability to control, and unless we hold the qualified examiners who have so much power in this case, as stated, who are central to this kind of proceeding, unless we hold them to the components of what menace is, of what a serious difficulty in controlling behavior is, it disappears.
Why isn't that fodder for cross-examination?
Your Honor, when it comes to meeting constitutional requirements, we never leave it up to cross-examination.
Well, no, but what I'm saying is, to the extent that the qualified examiner is testifying as an expert, is aware of what the foundational elements are requisite to a conclusion, an opinion that the person suffers from a mental abnormality in this context, then probing the detail and granular support for that opinion is something that is certainly available for questioning and challenge through cross-examination. Again, I think it's hard for me to see that it goes to sufficiency unless you're saying that for some structural reason, the expert's opinion in this context may not stand as sufficient in and of itself.
Well, Your Honor, cross-examination for all its benefits is not something that has to do with sufficiency unless the cross-examiner somehow manages to fill in the gaps in the direct testimony.
No, I understand that, but the point is that when we talk about sufficiency, we are looking at whether a rational trier of fact could accept the evidence. And here we have a statement by an expert that addresses the lack of impulse control, lack of volitional capacity, because in order to give the opinion that the person suffers from a mental abnormality, they necessarily must have satisfied themselves that criterion is met.
That would be devolving the judicial role onto the qualified examiner. That would be assuming okay, she's a qualified examiner, he's a qualified examiner, therefore, when he said X, he must have meant Y.
But
And I don't believe
No.
that.
we're just sticking to the actual facts of this case. Here, Dr. Rouse-Ware did more than just say he has a mental abnormality and it is pedophilia and exhibitionism, right? Didn't she go on to say that it predisposed him to commit these sexual acts, that in addition to the DSM-5, he also had the sexual deviant behavior, he had inability to control his impulses even while incarcerated, he had no completion of any sexual offender treatment program, he had lack of an understanding of what his own issues were. I mean, you're raising a sufficiency question, so I'm looking at the record and I'm not seeing how this works.
Because, Your Honor, none of the things you raised go to the central question of whether, despite all those problems, he has volitional control over his behavior. And Dr. Rouse-Ware specifically said it's not a general lack of power to control his sexual interests.
Right, and I think she
Really
said that because he wasn't looking, she said he doesn't have a personality disorder. He has a mental abnormality. Isn't that why not personality disorder? And so he doesn't have that general lack of control. But yes, on the mental abnormality.
The Constitution still requires the inability to control, however you phrase it, whether it's general power or serious difficulty. Proof of its absence is required. I agree with the Commonwealth that the two phrases can be interpreted equivalently, and the evidence here didn't meet either. If there are no further questions.
Thank you. For the Commonwealth.
Thank you. May it please the court, Shannon Buckingham for the Commonwealth. Just in first to respond to, I think what the justices are kind of questioning Attorney Hirsch on, I would say that counsel's argument that this general lack of power requirement is, if you were to agree with counsel's argument, it would mean that there would be no distinction between personality disorder and mental abnormality, but clearly the statute has distinguished between the two, and the statute is very clear, and the instructions to the jury are very clear, that in determining whether a person is sexually dangerous in that second group, that second element, you have to find a mental abnormality or personality disorder, or there could be both in various circumstances. And so I think that the record reflects that both of those things were explored by the experts from the Commonwealth. I think Dr. Rouse-Ware, who we've been talking a lot about, she in fact was asked specifically of whether she reviewed Mr. St. Martin for personality disorder. And that's where the conversation comes about, that she did review him for that purpose, but did not find that he met that general lack of power description for personality disorder. The other thing that it should be clear in the record, and it's something I explore with all the experts I examine, is that the legal definitions that are in the statute of mental abnormality and personality disorder are distinguishable from the clinical diagnosis. And so there's that discussion as well in their testimony. And
Counsel, do you agree with the proposition that the constitutionality of the statute depends on some proof of lack of volition?
Well, I think that the definition of mental abnormality, where we're talking about the congenital or acquired condition, where it predisposes a person for the commission of sexual offenses, making them a menace, that entire definition does incorporate that concept, although it doesn't use that exact language.
But can you say, I mean, predispose is a funny term because, if focusing on pedophilia, for example, if someone has no sexual attraction to prepubescent children, then presumably they're not going to commit a sexual offense against those children. So in a sense, their attraction predisposes them to the crime, but it doesn't mean they have a lack of volition. Aren't those two different things?
Right, but that's why the technical definition you're referring to in the DSM-5 is not the exclusive way in which to gauge whether a person suffers from pedophilia that would qualify as a mental abnormality. The distinction is that in an expert's opinion of whether a person suffers from a statutory mental abnormality, there has to be that additional predisposition, which I would suggest predisposition infers that there is that lack of ability to control. If somebody's predisposed to do something, it's more likely that they will be doing that action because of that predisposition. So I think that that's where the distinction between the legal and the clinical definition comes into play, and why we don't specifically rely just on those definitions in the DSM-5. And in this case, based on the evidence, Dr. Rouse-Weir was specific to say that because of Mr. St. Martin's history, his offending history, that he was, he did lack the ability to control his impulses. It was demonstrated by his conduct in the offending behavior as well as his subsequent conduct. And she does refer to those risk factors: the deviant sexual preferences, the antisocial orientations, his intimacy deficits, his poor problem solving, early onset, all of those things leading to the likelihood that he would reoffend and what makes him to be sexually dangerous. And I think those are all integrated into that mental abnormality piece and how the pedophilia affects his ability to be a menace. And I think that is where the focus of this case is on that terminology regarding menace. And, although Attorney Hershen's argument hasn't really talked about that particular component, I think that in bringing up in his brief, the Spring case, and that there was not a distinction made to the jury about contact and non-contact offenses, that was where that was sort of the way in which he was directing the argument, and that there should have been more to show that this reasonable that he.
Why wasn't the Suave Walker line of cases one of the obvious roads to go down if you're defending this case? I'm not saying it would have worked, but in terms of thinking through the defense of this case, why wouldn't that be the first thing you think of?
I can't speak to that. In this case, no new trial motions were filed. There were no affidavits provided by trial counsel for the defense in this case. So I don't know why, if the court is asking me whether I think that would be an objectively reasonable defense. I don't know. It's not my role in these cases to kind of.
Having started down that path, though, I'd like to spend a little bit of time talking about Mr. Hirsch's second argument, which goes to the jury instructions and the distinction between contact and non-contact offenses. What do you have to say about that argument?
So I think in this case, if reviewing the record, there was a jury instruction that touched upon language that is in the spirit of Suave when the definition of menace was presented, in which the instruction referred to the fact that if for the Commonwealth to show that Mr. St. Martin had a mental abnormality, that the Commonwealth must prove that it makes him likely to commit sexual crimes that even involve either physical contact or I'm just trying to state it accurately, that or contact.
I think it says physical contact or would instill in his victims a reasonable apprehension.
Correct. Thank you. So I think
why is that not the Suave instruction, actually?
And I would say that it is. It's not as specific as what maybe Spring it was addressing. And I think I made a point to note that in this case, actually, Spring came out while we were in the midst of trial. And there was discussion about whether Spring in a more specific instruction that would distinguish, that it's physical contact or non-contact that involves also instilling reasonable apprehension of fear of a physical contact. There wasn't that distinction made in this case. And in Spring as well, I think that it's distinguishable on its facts in that case, we're kind of in the reverse situation. And in this case, in Spring, it was a series of non-contact offenses that were closer in time to the petition. And in Spring, the jury specifically asked questions, noting that there was this issue in their mind, in the minds of the fact finders, to determine whether non-contact and contact offenses should be considered differently. So I think that the instruction given was sufficient. I think that Spring is not necessarily applicable in Mr. St. Martin's case. And I also think that even if a more specific instruction about contact and non-contact was provided to the jury, that it would actually have been a little bit more misleading to the jury in light of the way the evidence was presented and the theories that were identified. In this case, trial counsel did not pursue the idea that, well, Mr. St. Martin's non-contact offenses show that he doesn't have to commit a contact offense. There wasn't that distinction as it was presented in the defense of Spring. So I think that the instructions were sufficient in this circumstance. I think that the evidence was sufficient. And even if the court were to find that, if this court were to find that maybe a little bit more should have been provided the instruction, I would suggest that Mr. St. Martin, the defendant, was not prejudiced by the instruction given, and that the evidence would have been sufficient for the jury to find that he was a menace based on the non-contact offenses as well, simply based on the actual non-contact offenses. His more recent offense, the 2003 offense involving a woman where he approached and exposed himself and made comments to her, the comments in their nature were alluring. In the prior incident where he, in the 1993, I believe,
in that incident, didn't he turn his car around and follow her?
He did, and I believe the police report, which is part of the record, also reflects that he had a child in the back seat of the car at the time that he approached that woman on the side of the road. And then going back even further to the other non-contact offenses, when he approached the young ladies at the Kingston, the Independence Mall parking lot, he also then approached those women, exposed himself to them, got in the car and followed those women, followed the women around the parking lot, so that they actually reported to the police that they stayed in that parking lot because they were afraid to leave, afraid that he was going to actually get to them and that he would do something to them. So
in fact, wasn't there testimony that they not only stayed in the parking lot, but they kept driving because they were scared of what might happen were they to stop?
Correct. And that's contained also within the police report that was presented as an exhibit that did specifically identify their statements that were at least one of the women.
And in addition to all of that, by some perspectives, the most significant sexual offenses were the series of assaults against the young child victim from 1997, continuing over a span of 7 years until 2004, all of which were contact offenses.
Correct. And that's the bulk of the Commonwealth's argument on sufficiency and about whether we needed to actually even distinguish between the contact and non-contact offenses. Because here, the governing offense, although it doesn't have to be a contact offense, it was a contact offense. And it was a series of offenses that occurred repeatedly over a period of time. And so I think there's a fair inference that, although maybe the experts did not specifically say he's likely to reoffend with a contact offense, the fact that the bulk of the defendant's offending behavior involved contact offenses, I think it's fair to infer that that's what the theory of the case was, and that's the focus, and that's what everyone was discussing when all the experts testified.
But counsel, at least in the SORB context, a big deal is made between intrafamilial offending and offending against the public at large. And, certainly an argument could have been made here that the contact offenses were, in some sense, sui generis, given that they involved someone in his household. I realize that this may be counterintuitive to the lay public, but again, at least in other parallel contexts, a big deal is made of whether or not someone's offending is limited to the family.
And I think that Your Honor is correct in that that piece of it, that distinction, is usually something that is developed when talking about risk assessment. And to some extent, it's part of these proceedings, where one of the facets that we're asking the jury to decide about is that likelihood of reoffending and the recidivism risks. And it is correct in saying incest offenders, usually their likelihood of reoffense is not as great as it applies to risk. But again, in this case, based on all the evidence presented, the experts did provide testimony, and their reports indicate that they provided that risk assessment where that is accounted for. And that in Mr. St. Martin's circumstances, there are certain things that maybe mitigate his risk, but there are other factors, dynamic factors, that increase his risk. And that in balancing those things, all experts agreed that Mr. St. Martin's protective factors, or those things that might reduce his risk, were greatly outweighed by the risk factors, the dynamic risk factors that they all discussed at length regarding his deviant behavior, his intimacy deficits, the kind of offending that he had, that he acknowledged that he used sex as a coping mechanism, the fact that he hadn't undergone sufficient treatment over the course of time to be able to effectively manage those things. So I think that while that might be a factor, that it wouldn't have negated the plethora of dynamic factors that were present in this particular circumstance, enough that it would have been successful for the defense to persuade the jury. Does anyone have any further questions? I would just rest on my brief for the remainder. Thank you.
Thank you both. We will resume in a moment with the next case.
Thank you.
Are we live?
It's preparing to set up. It's currently being live streamed.
Okay, now we move to our second case for argument this morning, case number 2019 P510, the Commonwealth versus Eduardo Velez. For the defendant.
Thank you. May it please the court. My name is Nicholas Morris. I represent Eduardo Velez. This is a case where there's two issues. The first is whether or not the trial judge incorrectly denied a motion for a required finding on the witness intimidation charge, which is count 2, based off the fact that the defendant took the victim's cell phone and used it himself to call the police, thereby challenging whether or not he intended to interfere in a police investigation first, and second or not, whether or not, based off the particular facts here, there was a possible criminal violation to report at the time that particular call by the defendant was made. The second issue regards count 1, which is assault and battery on a family or household member, and whether or not a specific unanimity instruction, although not requested by defense counsel, should have been provided by the court, where the facts as testified to by the victim are discrete and sequential assaults. However, I would argue they're not a continuous course of conduct because there was an interruption in the assaults as they happened, and therefore it wasn't continuous, and there should have been a specific unanimity instruction. First, with regard to the witness intimidation count, the assault began in the bedroom. There was a verbal argument. There were clothes being thrown by Miss Ayala, the victim. At some point, Miss Ayala struck Mr. Velez. At some point, Mr. Velez struck Miss Ayala. At that point, Miss Ayala went and walked into the living room with her cell phone, where Mr. Velez sort of pushed her out of the way.
Counsel, we've certainly read the briefs and the record, so we understand the factual arguments. I personally am having a hard time seeing why the grabbing of the victim on the bed is not sufficient evidence of an assault and battery, of an actual assault and battery, and therefore, ipso facto, sufficient evidence of a possible crime.
because right around the time that that had happened, Miss Ayala had committed an assault herself by throwing clothing at Mr. Velez.
Does
Well,
her
well-
assault negate the possible criminality of his assault against her?
It doesn't negate it, but it creates a situation where Mr. Velez, by grabbing her, acted with reasonable force in his own defense.
Well, no, but the standard isn't whether it's compelling that's the only possible conclusion that could be reached. It's a question of whether there's a possible criminal act. And to Judge Milkey's point, his grabbing her constitutes a possible criminal act. Her use of the telephone to summon police and his interference with that attempt seems to be fairly closely aligned with the elements of witness intimidation.
To the point of the interference with the attempt to call the police were called. Mr. Velez called the police.
That came later. That's true, but he called them and gave them a radically different version of events, which the police and eventually the jury rejected. But let's just focus on the question not of who was right and who was wrong, but the question framed in the argument that you were making here, which is the sufficiency of the evidence in the eyes under Lattimore of a rational trier of fact. Viewed in the light most favorable to the Commonwealth.
In the light most favorable Commonwealth, the police, as regarding the intent to interfere, the police were called, the police arrived, the police conducted an investigation. Now, Mr. Velez may have given a different story to the police, but whatever story he gave to the police resulted in their arrival at the apartment to do.
Well, understood, but we're not looking at his summoning of the police because he summoned them under a very different narrative. The question is whether, when he grabbed the cell phone from her, whether he, in doing so, interfered with her effort to call the police. Isn't that fairly straightforward?
If the police were not called, I think the police being called changed
No,
that.
he didn't. He prevented her from calling the police. Correct?
Yes.
Okay. The fact that he subsequently called the police doesn't mean that he didn't interfere with her attempt to do so, right?
Yes.
Okay. So when we look at the elements of the offense, the question is whether there was a possible crime and interference with an attempt to initiate an investigation of that possible crime by a reporter. I'm not sure which portion we're still arguing about.
I just want to make sure I have the language correct because
Well, you're certainly more likely to do so than I am.
Reading from the model instruction, it's the defendant did so with the specific intent to impede, obstruct, delay, or otherwise prevent a criminal investigation of any type.
Right.
So I think the distinction I'm trying to draw versus what Your Honor had asked me was, Your Honor had asked, did he impede her attempt to contact the police? And yes, he did, based off the facts of this case. What I'm saying is, but that's not how the language of the instruction is written. The language of instruction is written as impeding an investigation, not an attempt by an individual.
So by your analysis, a subsequent initiation of an investigation would negate any previous interference with the attempt to initiate an investigation by someone else.
I think that gets into the time that had passed between the two, I think becomes important.
Well, I just want we can start down the path of the spectrum of the temporal proximity, but I just want to make sure I have the foundational elements of your argument laid out first. So what you're saying is that a subsequent investigation negates the interference with a prior attempt by a different person to initiate an investigation.
It may, depending on the particular facts, yes.
Okay, and what is the best case that you have to support that proposition?
I could not find any cases that would support that proposition, and I think
So you're asking us to create one?
I'm asking you, I guess, yes, then, to look at the facts of this particular case and decide whether or not in the quick sequence when the phone was taken and he called the police, whether or not that's sufficient to get to Your Honor's point about negating the interference of her original intent seconds or a minute before.
Counsel, break it down. At the point he took the phone from her, he may or may not have formed an intent to call the police himself. Let's say he hadn't formed that intent, and that he subsequently made a decision to call the police. Then I would take it you would concede that under those assumptions, his intent to impede was there.
Yes.
Okay, now let's take the opposite, that at the time he took the phone from her, he already had made a decision to call the police. So he wanted to affect how the police received the information about what had happened. Why isn't that itself enough to intimidate a witness, interfere with an investigation, etc.?
I just want to make sure I have the question clear so I can answer it. So what Your Honor is basically saying is assume that he had the intention to call the police as soon as he took the phone.
Before he decided, okay, I'm going to call the police and I'm going to steal her phone and do that.
At the time he took the phone. So the question you're asking me is then, if he decided to take the phone, call the police, and then give the police the different story, is that then impeding the investigation by sort of jumping the gun? Because
his intent is to be the first responder, if you will, not the responder, the first initiator.
Right. In response to that, what I would say is that, well, that presumes the police aren't going to show up and do their own investigation.
No, it doesn't. The question is when we look simply at what the statute is looking at for, the question is he interfering with her attempt to initiate an investigation?
My argument is I don't agree that the statute requires, and it's her investigation. I would say it's any investigation.
She is attempting, I'm not saying it's her investigation. She was attempting to initiate an investigation. He interfered with that. Right?
No, not based off how quickly he called the police himself.
He interfered with her attempt to do so. The fact that he separately initiated an investigation is, it seems to me, a different question from whether he interfered with her attempt to do so.
He could have if there had been a substantial delay. But to the original question that I hadn't answered yet about him jumping the gun, him being the first reporter to the police, what I think becomes important then is that if he reports to the police that there's a domestic situation going on and he's the victim in his eyes, well, then I don't know that interferes with the police investigation, because all that does is begin the investigation. And when the police arrive, because he said to her, I believe the statement was something to the effect of, now you're going to be in trouble. The police are going to come. You're going to go to jail. DCF is going to take your children away, something like that. That would then imply that the police are going to ask her what happened.
The threat that she is at risk of losing her children is another form of intimidation, but we can set that to the side for the moment because of the removal of the cell phone.
Can I get back to one of your factual premises, namely that the throwing of the clothes occurred prior to the grabbing of the victim? The testimony is not a model of clarity in terms of the timeline, but I personally tend to agree with the Commonwealth that the more natural reading is that the throwing of the clothes happened after the grabbing of the hand. That being the case, then under a Lattimore standard, isn't it plain that we have to assume that there was no throwing of the clothes before the grabbing of the hand? So as a matter of fact, that argument fails.
You could find that, Your Honor, yes, but that's only one of the two elements that I'd be challenging. And that would go towards the possible criminal violation. So if that's the reading Your Honor takes, and under the Lattimore standard, it is what it is. But that doesn't get around that we also have to find the intent to impede.
What you're saying is that his initiation of an investigation close in time to his interference with her effort to do so absolves him of any criminal culpability for interfering with her attempt to initiate an investigation.
I would use.
I know you frame it in different terms because the terms that I used were a little harsh sounding in terms of the logic of the argument, but it seems to me that they are fair to the argument itself.
Having said, I do disagree with that, but I understand Your Honor's point, and I don't mean to belabor that, given that we've been discussing this for.
Can I ask you a question, counsel?
Yes.
How does this theory that you have on the lack of intent because of the close temporal proximity of his call versus his interference with her call fit with your other argument, and that there should have been an instruction to the jury?
The specific unanimity instruction, Your Honor, is that?
Exactly, because the Commonwealth saying this all happened as a series of closely temporal events, so it's all one. And it sounds like in the context of saying lack of intent, you're saying this all happened really quickly, which is, I think, affirming the Commonwealth's argument.
What I'm saying happened really quickly was when he left the bedroom, she says, "I'm going to call the police." He pushes her out of the way, grabs the phone, and calls the police himself. I'm saying that portion of the sequence happened very quickly.
Right, and in the interim, she searched for the second phone, he pulled her hair. All three of the assaults happened in that interim. And so I wonder, given your argument on intent, how that doesn't actually support the Commonwealth's argument that this was a series of really closely linked temporal and geographically similar events.
So to sort of quickly generalize them, because I have a little bit of time remaining, I sort of put in one category what happened in the room with the grabbing and the throwing of the clothes. She then gets up, leaves, walks into the living room, and I think that breaks the sequence up of what happened in the bedroom to what happened in the living room. And
They're
then what happened
adjacent rooms, aren't they?
Yes, they are. I believe they are. That was the testimony. Then what happens in the living room with the phone happens. Then she goes back into the bedroom, I believe, to look for the second phone, which brings it to the sort of third grouping of the assault, is him going in and pulling the hair.
And
So I think
still he hasn't called, right? He hasn't called the police yet.
I believe he called when they were in the living room. Then she goes to get the cell phone, the second cell phone, to make another call to the police to give her report of what had transpired. But a lot of the cases that deal with this issue, the continuous assault is much different than here, where there's walking around the house, there's going to look for cell phones, there's attempts to call the police. That is what I think makes this different, than the cases cited by the Commonwealth and even the cases I cited in my brief.
All right. I see that your time has come to an end. Unless there are further questions, we'll hear from the Commonwealth. Attorney Townsend.
Thank you, Mr. Chief Justice, and may it please the court, Thomas Townsend for the Commonwealth. If we get back to basic criminal law, the crime is complete when we have a concurrence of the actus reus and the mens rea. That occurred when the defendant followed the victim out of the bedroom into the living room, grabbed her phone, and pushed her. As he was following her, he was tried to dissuade her from calling the police by saying, "If you call the police, they will take away your child." That demonstrates quite clearly his mens rea. He wanted to prevent her from calling the police. He grabbed her, took the phone, and pushed her. We have the concurrence of the actus reus and the mens rea. What he does after
actus reus? I'm confused. I thought your theory was that in the bedroom, he tried to grab her arm and she, volleyed.
That was the first assault and battery.
Yeah, and I thought that was the possible criminal violation that the Commonwealth's theory on witness intimidation was.
That is the possible criminal violation. Okay. Then we have the actual criminal act is seizing the phone from her and pushing her. So the crime is complete at that point. What he does after the fact is irrelevant. And I think a fair reading of the facts here is that he called the police or stayed on the phone after she had, already called the police and gave his version because he wanted to preempt and give the story to the police before they got her story. And so in fact, the police were dispatched to the apartment on a call of a female threatening a male with a knife. And we know that was not true. But he was able to get that story to the police first because he knew at that point, she had not called 4 weeks ago when he had assaulted and battered her. She had not called a week or so earlier when he assaulted and battered. But he knew this time she was serious about calling the police, so he wanted to get his story to them first, or at least that's a fair reading that the jury could accept. And I think.
Can I ask you a question on the sufficiency of the intent and so forth? Your brother is relying in part on the specific language of the model jury instruction as opposed to the requirements of the statute. For sufficiency purposes, don't we go by the statute and not the instructions?
We do go by the statute, and there's a plethora of cases out there that say the model instructions are not the law, that there are currently errors in the model instructions in various statutes.
I understand, but the model instructions were how the case was presented to the jury. So just complete hypothetical, were we to conclude that under the jury instructions, there's something to counsel's arguments, what, if anything, do we do with that? Do we dismiss that as, oh, well, that's not really a sufficiency argument, or is there still some import to draw from that?
Well, I think, well, if we're looking at the error by the judge, if there were error occurred when he denied the motion for required findings. So this predates the jury instructions. But I submit that I'm not so sure that there is a huge difference between the case law and the model instruction. I think it's clear that where a defendant chases after a victim, says, do not call the police because this bad thing will occur in consequence, takes a cell phone and pushes that victim under any version of the statute, and we're dealing with a prior version of the statute here, that is witness intimidation. It was witness intimidation back in the 90s under Belle Isle. That's the case where the defendant ripped the phone cord out of the wall. That was witness intimidation, and that's still good law, even though it was under a very different version of the statute. That's good law up till today. If we look at, say, the King case, which I said on page 17 of my brief, the question is whether the defendant intended to discourage such communication. Clearly, by his own words and by his own deeds, he intended to discourage such communication. And so I think this is a clear-cut case, and we review the facts in the light most favorable to the Commonwealth. And this novel argument, which is made here, wasn't made at trial. It was just a boilerplate motion for required finding. It doesn't withstand scrutiny under the facts of this case. And I just want to touch upon the throwing of the clothes. I think that is a misreading of the testimony. I agree, the testimony is somewhat confusing, but it made no sense because clearly, and even the defendant in his brief admits this, the first assault and battery allegedly occurred on the bed when they are seated together on the bed. It makes no sense that she would go sit herself on the bed after erupting and throwing clothes. The only evidence is that she threw clothes, and I have a block paragraph in my brief, page 15, where I word for word verbatim the testimony. She said, I tried to get up from the bed and he tried to grab me by my arms, so I shook him off. Later on, if you drop down, I started throwing stuff at him. And then there was a follow-up question, what did you throw? It was the clothes. So clearly, she threw the clothes after the initial assault and battery. Not that any of this makes any difference. If someone throws clothes at someone, that doesn't give you carte blanche to strike them. That's at least a possibility of criminality. And that's what the statute looks for. The defendant argues extensively about self-defense in his brief. That was never mentioned at trial. There was no jury instruction on self-defense. That was not a claim of defense.
How do you address the point that while she used the word grabbed at one point, at 2 or 3 other occasions, she talks about he tried to grab me?
Well, again, if we look at the evidence in the light most favorable to the Commonwealth, he grabbed her. I mean, we have A, we have B, where the jury can credit either one. If we're looking at the light most favorable to the Commonwealth, he grabbed her. And I think the defendant's contention is that grabbing occurred after she had somehow assaulted him. He's not denying the grabbing. And that grabbing, as was mentioned earlier, is sufficient to constitute an assault and battery. And I cite later on in my brief, the Morin case. If you grab someone's arm to restrain them, that's a battery. Now, again, my point being, even if she had thrown clothes at him, which is not borne out by the transcript, that does not give him permission to commit a battery.
What
Unless
is
somehow,
our reading of the, well, let's just say the language had been, he tried to grab me. Would that be enough then for the witness intimidation?
I think that could be an assault. That's a threatened battery. So if I try to punch someone or I make a motion to punch someone, that's a threatened assault. It's not an assault and battery, but that is criminality under the statute. So if someone.
So even the language tried to grab is sufficient for meeting the first element of witness intimidation?
Oh, I think, yes. So if we just ignore the testimony that he grabbed me and just focused on that other testimony, let's say we take the evidence in the light most favorable to the defendant, that's still an assault. And that's still potential criminality, which is all that's required under the case law. And so even under the best of worlds for the defendant, he's still guilty, and the trial judge still properly denied the motion for required finding of not guilty.
And remember whether the prior assaults on the two previous occasions were part of the evidence at trial to provide context.
They were, and actually they were charged, and the jury found him not guilty of those.
Right.
But
Okay,
my argument is
no, but I understand. My thought is that those, in terms of assessing what might constitute an assault, placing someone in fear of a threatened battery, they lend context to the circumstances in which the victim found herself at that moment.
It certainly does. She could have been intending to alert the police to that battery that had just occurred, or she could have intended to alert the police to the prior batteries. And when the police did respond, she told them not only about the batteries that had just occurred, but the ones on the prior weeks. And in fact, she was asked on cross-examination, I'd strike that, that's a different point. But the point I wanted to make is those other ones, even though he was found not guilty of it, and I drop a footnote at the beginning of my argument section, it's still relevant to consider her mindset on whether she intended to alert the police to past criminality. And those. You
want to spend some time on specific unanimity?
I think it comes down to the question. Now, this was not requested, so we're dealing with substantial risk of miscarriage of justice. But I think the judge, even if he had or she had been requested to provide that instruction, would have been warranted and not, because we're looking at whether it's a continuing course of conduct on one hand, or clearly detached incidents. And that's the language that the SJC uses in Shea and Santos. If they're clearly detached incidents, then perhaps a specific unanimity instruction would be warranted. But if it's a continuing course of conduct where the spatial and temporal separations are short, there's no need for a specific unanimity instruction.
Is there any guidance in the cases about the significance of separate rooms within a single dwelling?
Yeah, I cited a couple. I don't like to cite unpublished decisions, but when I want to,
we don't like to rely on them either.
I'm glad Justice Engler is not on this panel. I'd hear from him. But if I'm looking for a specific,
I won't tell him you said that.
He'll take it as a compliment, I'm sure. But if we're looking at this specific factual similarities, I will cite some cases. So I do cite a couple cases, and they're in my addendum, where an attack starts in one room and ends in another. The case I like even more is the Shea case from the SJC, which wasn't an assault and battery case, but was a restraining order case, where the first violation of the restraining order occurred in the courtroom when the victim or the defendant were passing each other, and the defendant said something not very nice. One of them was the defendant was escorted outside the courtroom by court personnel, and then they came to escort the victim out about a minute or so later. The defendant was hiding in the stairwell and said something not very nice and took a photo of the victim. And the SJC used all this language about spatial separations and temporal separations, and they went right up to saying that those were one continuing course of conduct. But then they pulled back and said, well, even if it was error, it was not substantial risk of miscarriage of justice. And so we have that here. Even if it was error, it's not a substantial risk of miscarriage of justice because there was sufficient evidence for all three assaults and batteries, and the defendant even admits that in the brief. And that's the undoing under the substantial risk assessment. If there's, and Keevan is the case, which I cite from the SJC, if there is sufficient evidence for each of the underlying crimes, there can't be a substantial risk of miscarriage of justice because we could have charged 3 crimes here, presumably, but I think that we'd be open to the charge of overcharging. So if we did one here, if the defendant wanted a specific unanimity instruction, the judge could have turned to the prosecutor and say, okay, pick one. Which one do you want me to instruct the jury on? And that would have happened. So the defendant shouldn't benefit from holding his tongue at trial and then argue on appeal that somehow there was error that for failure to provide instruction that was never even requested. Unless there's further inquiry from the court, I'm willing to rest on my brief.
Seeing none, thank you both. We will return to the waiting room and resume the session with the next case. Hearing list with case number 2019 P1838, the Commonwealth versus Michael Ahern. For the defendant, please.
Good morning, Your Honor. May it please the court. My name is Sean Smith and I represent Mr. Michael Ahern. This appeal is a direct appeal from the trial verdict. And I recognize from the get-go this has some unusual procedural history and I am in unusual procedural posture, given the very fact that we have a 2019 decision from this very court on this very case.
If I recall correctly, I was on that panel.
You were. And in that exact case, as Your Honor would remember, this that court, that decision overturned my successful motion for new trial based on prosecutorial misconduct. I did not appeal my successful motion for new trial.
Counsel, putting aside whether or not you appealed it, did you argue in the prior appeal that this court could affirm on the alternative grounds that you're now arguing?
No, as the decision itself said in one of the footnotes, the ineffective assistance of counsel was not raised by the defendant at that time. I did brief the issue for this court. I briefed both issues, and I believe the Commonwealth did respond.
So I'm confused by your answer then. If you briefed the issue as an alternative ground on which we could have affirmed, why wasn't it in fact argued?
I don't know. The court chose not to. The court chose not to take it under consideration. Chose not to hear it.
Well, the court. What the court appears to have said is it wasn't argued, and I'm hearing you say it was argued, and I'm just trying to sort that out.
So I did not appeal for the motion for new trial, which was my decision in not appealing the motion for new trial was I decided that the trial court was correct in finding no ineffective assistance of counsel because there was prosecutorial misconduct.
Well, but I mean, I don't frankly understand how you even could have appealed, given that you won the motion.
Agreed.
For new trial.
Agreed.
You could have done.
Oh, go ahead.
You could have cross-appealed the adverse ruling on the ineffective assistance claim.
That's correct. But at the time, I did not believe that the judge ruled incorrectly. I believed that there was no ineffective assistance of counsel because
in effect, your appeal from that issue would have been the judge was correct that I win, but he got the wrong reason. And that to me doesn't sound like an appealable, something that you would argue on appeal. Instead, you would do what you did, which argue the ineffective assistance as an alternative ground to affirm the grant of the motion, right?
I prepared it and I did brief it, and I believe
you submitted it to this court.
I did, but the court did not take it under consideration.
And that's my question to you. Did you file a motion to reconsider on that alternative ground, given that it was not addressed by the prior panel?
I did not.
Okay, and so given that, can you explain to me why you have not waived that argument?
I have not waived that argument because the 2019 decision, the change in terms of what is prosecutorial, the decision that what the prosecutor had done in his closing argument, the decision that was proper, that was allowed, has transformed the ineffective assistance of counsel argument. It has expanded the error of ineffective assistance of counsel, and it's compounded the prejudice. What the 2019 decision did was what the 2019 decision said is in circumstances, in instances where defense counsel promises a witness at an opening statement, and then during that trial fails to call that witness, the prosecutor at closing can not only highlight the fact that there's missing evidence and a missing witness, but can then argue facts not in evidence. And that damage done to the defense counsel was something not contemplated in the original ineffective assistance of counsel claim that I presented to the court. That is something new. And for that reason, I have not waived.
What's new about it? I mean, I'm having trouble understanding the difference between the bare ineffective assistance claim and the alternative ground that Judge Muse found and we overturned on the improper closing argument.
I'm sorry. Well, I'm sorry, Judge.
I don't see the relationship between the improper closing argument and the ineffective assistance on the failure to produce a promised witness. I just don't follow.
Judge Muse if we're talking about Judge Muse's argument was there was no ineffective assistance of counsel because what defense counsel had promised in terms of evidence and testimony was about the whereabouts and the sobriety of Mr. Ahern from 5 p.m. to 10 p.m.
There were several different layers to that. There was also concern that it would discredit the credibility of the defendant based on contentions about ownership of the bar, and also the fact that it was a collateral, relatively scant importance in the overall theory of the case.
Well, Judge Muse's decision, I agree with Your Honor in the sense that he said, one, it's irrelevant because there was no evidence put at trial that he was drinking by the Commonwealth. That was one argument that he had. It was ultimately irrelevant because the evidence would have come in and it wouldn't have gone to anything in particular.
Well, it was irrelevant because the gap in time between the time he left Slate Bar and the time he was apprehended intoxicated was something like 4 or 5 hours. That's
right. And had the Commonwealth not then argued that he was drinking from 5 till 10, had they not argued it, there wouldn't be an issue. The problem is that the prosecutorial misconduct put in that he was drinking from 5 to 10.
You argued prosecutorial misconduct and you lost that one too. And you argued precisely that theory.
I agree. I don't argue with that theory. The prosecutor is allowed to do that. They're not only allowed to highlight the missing evidence, they're also allowed to argue and infer facts not in evidence like this case. I think that's exactly what the case stands for. Because that was the penalty, because that's what defense counsel suffered, because he decided and elected not to call his witness, despite, for strategic reasons or for irrelevancy reasons, that error is now changed. It's fundamentally more problematic.
Not at all, because Feeney would have been able to supply nothing about the defendant's whereabouts during that 4 or 5 hour gap.
Mr. Feeney would have been able to argue his sobriety up until around 10 o'clock.
He left Slate, I thought, around, what was it, about 7, 8 o'clock, wasn't it? 9 o'clock?
He left Slate Bar at around 11:58, almost midnight. He was at Slate Bar from 10 to about 11:58.
But when did he meet? When he met with Feeney in the afternoon?
The Commonwealth brings in evidence they had a beer at Salle de Terre at around 5.
Right.
And then he has a community meeting with Mr. Feeney at around 7, 8. There's that time period. And so that he would say, I met with Mr. Ahern, he was perfectly sober. And
at 7 or 8 o'clock at night, but the time when he is intoxicated is many hours later after he has not been with Feeney.
Well, the idea that he's intoxicated then is a live issue for the jury. The question is, was he drinking all day, where it's obvious that if you've been drinking all day, then of course you're intoxicated by the time you left the bar. And what the problem with this case isn't that he didn't call Mr. Feeney, is that there was no evidence of drinking throughout. And that's
the argument on the prosecutor's suggestion that he'd been drinking all day. Feeney's evidence, Feeney's testimony bears not at all on what he did during the time after he left Feeney and the time when he was found to be intoxicated.
But the prosecutor would not have been allowed to then argue that you didn't hear it, you didn't hear Mr. Feeney, therefore use your common sense, he's been drinking since 5. And that is what changes the case dramatically. That is what adds the level of prejudice and error to this case.
But there were tactical and strategic reasons I mean, I understand the theory, but there were and we still need to get back to waiver. I'm not certain that the idea that the claim looks different in the light of the adverse ruling, because both of those claims were presented to Judge Muse, and both of them were in front of the court on the first appeal. You could have, I mean, setting aside whether you cross appealed, you could have moved for reconsideration. You did file for further appellate review. That was denied.
It was denied.
So I'm back to waiver, but quite apart from waiver, even with everything you've said, I have a hard time finding fault with Judge Muse's initial ruling that there was no manifestly unreasonable tactical strategic decision.
Well, I'm sorry, Your Honor.
No, I just want to ask a clarifying question.
Sure.
You do not appear to be arguing that the ineffective assistance here was mentioning this in the opening statement as opposed to not calling the witness later. I mean, one could conceive of this as saying that where the counsel was really ineffective was in promising the jury they'd hear from this witness without thinking through all the problems with that. But you don't appear to be making that argument.
I think the two are of a piece. I think it is always strategic error for a defense attorney to promise a witness that you may or may not call, that you may not have thought about the strategy and going toward it. But I do think that the defense attorney, after listening to the Commonwealth's case on opening, the Commonwealth was clear in its opening. Mr. Hearn started drinking at 5, and he made bad decisions throughout the day, kept on drinking, and then at midnight, he ended up crashing into this individual. Because of that, because of the drinking all day, that's what happened. So the defense counsel, I thought, reasonably said, well, I better get a witness to talk about him being sober during that time period, that he wasn't drinking all day. And in fact, he did promise that witness. I don't think having a witness ready to go to answer that point is ineffective. I think ultimately calling a witness, or promising to call a witness and not doing it, that is ineffective. So in a sense, it's the same if that he wasn't prepared with his witness. But I also take issue with the strategic concerns. I think before Judge Muse believed firmly that the prosecutor should never have been able to argue facts not in evidence. So he wouldn't have seen the level of error in terms of balancing the unreasonable. Is it manifestly unreasonable? These strategic concerns. The issue was sobriety at this trial. The issue was clearly sobriety, and where there was no breathalyzer, where there was no blood draw, where there was no field sobriety tests, and where there was no confession. These were all observations, and the trial judge who was there believed it was a live issue, believed sobriety wasn't overwhelming evidence, and believed that the strategic concerns only made sense because the prosecutor never should have been able to argue that he was drinking all day in the first place. The fact that now he can argue, and I'm not debating that, he can, that makes the error even more problematic to call a witness to allow a prosecutor to do that.
I want to back up just to clarify one procedural question before we lose you. As you pointed out, this is in an odd posture because it's here on the defendant's direct appeal after the disposition of his separate appeal on the new trial motion, the Commonwealth's separate appeal on the new trial motion. When I look at the Commonwealth's statement of the case, I see that the direct appeal was first entered here in 2016, and that was stayed pending the new trial motion. And then this case bears a 2019 docket number, so that it was that this appeal entered in the case after the decision in the appeal from the new trial motion. What happened to the first direct appeal?
My memory and my recollection of that is we had stayed it for a status, waiting for a decision, and that ultimately at a certain point, The case was dismissed without prejudice pending resolution to this issue because of the length of duration.
I see. Okay. All right.
And I would also just quickly point out in terms of overwhelming evidence, this is an issue that I clearly this court addressed it in the first case. There was overwhelming evidence, even if the but regardless of the ineffective assistance of counsel, there's overwhelming evidence. I would again put forward to Your Honor that the person in a great position to see that a reasonable person who thought otherwise was the trial judge. The trial judge heard the cross-examinations, saw the evidence come in. He thought sobriety was a live issue at that time. And he very much thought that what the evidence supplied by the prosecutor could have very much weighed in, and he had that higher standard of proof in terms of injustice. I would put to Your Honor that reasoning should also be taken into consideration in this motion.
Thank you.
Thank you.
For the Commonwealth.
Good morning, Your Honors. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. Can you hear me?
Yes.
Okay. The Commonwealth respectfully requests that this court affirm the defendant's conviction where the defendant's sole claim of ineffective assistance of counsel is not properly before the court and in any event lacks merit. So I'll start with the issue of procedurally whether or not it's properly before the court, and it's not. The motion judge allowed the defendant's motion, and the defendant brought a motion for a new trial raising two claims, ineffective assistance and prosecutorial.
I think we all know the procedural history here. I'm wondering why you think it's waived. If I'm a defendant and I've just won a motion for a new trial, why would I ever appeal?
Well, that's a strategic choice. So you could file a cross appeal.
I can't do better on an appeal than I've already done. Why would I ever appeal? I don't even understand.
Well, there's a question of the counsel. There's a question of why would you do it, and then there's a separate question: could you even do it? You appeal judgments and orders. You don't appeal reasoning. This is not the U.S. Supreme Court.
Right, but if the court allowed the defendant's motion, which it did, and that the propriety of the motion judge's order was on appeal, which it was, and you wanted to preserve one of your claims, which was decided, then you could file a cross appeal as to that claim.
I think Judge Milkey's point on that is that it's not necessary to file a cross appeal to defend a ruling on an alternative ground.
I apologize.
No, but and here the parties seem to agree that the argument was made to the former panel that it could be affirmed on this alternative ground. And then I have this curious last sentence of the last footnote of that case, which says that the defendant does not challenge that decision here. Is that a factually correct statement or not?
No, it is no. The Commonwealth does not agree that the defendant properly argued that issue raised that issue in the first case. The Commonwealth briefed its claim. The defendant filed its responsive brief in which he did raise this claim. The Commonwealth moved to strike that portion of the brief, basically for the same reason as here, saying he never appealed from that. He never claimed that that ruling was problematic for him. He never filed an appeal from that decision. So that issue wasn't properly before the court. Then this court noted it, or the court didn't act on the motion to strike. There was never a ruling on the motion to strike. Then in its footnote 7 of the decision, the court said the defendant also argued that defense counsel had been ineffective when he told the jury in openings, and he goes through that claim and says the defendant does not challenge that decision here. And the defendant, even after this published opinion issued, the defendant did not move for reconsideration or rehearing on that point. So that's the end of that claim.
Well, I think
the motion for a new trial apple.
I think that there are differing views of what was before the court. I tend to agree with Judge Milkey that the cross appeal from an alternative theory is not necessary to bring that as an alternative ground to affirm. But if the panel decision in the footnote was factually incorrect in stating that the defendant didn't challenge it, then the failure to challenge that misstatement in a motion for reconsideration may well serve as a waiver.
Yes, and the Commonwealth's position is that it does. But even if this court were to consider the merits of the defendant's claim, there's simply no basis in the record from which this court could conclude that Attorney O'Malley was ineffective in failing to call Mr. Feeney. I think the court should consider what is and what isn't before the court. There was not an evidentiary hearing conducted on this point because Judge Muse denied this claim without an evidentiary hearing. There was no affidavit from.
There were affidavits. I guess there was some difficulty getting a full affidavit from trial counsel because by then he'd been appointed to the district court and he didn't seem responsive to the efforts to reach out.
Well, there were two attorneys. First of all, there was Dan O'Malley and there was also John Cerullo, both who are both active members of the Massachusetts Bar. And my recollection is, and I'm sure Attorney Smith will correct me if I'm wrong, but Judge Muse ordered Attorney O'Malley to respond if that was needed. That happened at the non-evidentiary hearing. He said that you could write a note to the Attorney O'Malley saying that he needed to respond as an order to Judge Muse, and my Attorney Smith is confirming that that is true. That was never done either because the claim was decided in his favor. So I have never seen an affidavit from Judge O'Malley. I have never seen an affidavit from John Cerullo, and there was never an evidentiary hearing on this. So you're left with the papers and the defendant's pleading. There is an indication from both Attorney Smith, an affidavit from Attorney Smith and an affidavit from Attorney Naris that they did, one got a voicemail, Attorney Naris got a voicemail from Dan O'Malley, Judge O'Malley. Attorney Smith spoke briefly with Attorney Cerullo, and both said there was a strategic reason why Mr. Feeney was not called. And there is no possible way that given the reason that they provided, that could be seen as manifestly unreasonable. They believed that it would undermine the defense, and they believed that it was irrelevant. His testimony was irrelevant. And as this court noted on page 201 of its decision on the motion for a new trial, they didn't call him because they learned that the defendant was not one of the owners of Slate. And it was believed that the information would discredit the defendant, and that the testimony that he would have provided was irrelevant. He was going to testify to things that happened up until approximately 9 p.m. when he parted ways with the defendant.
Counsel, from your perspective, did the defendant ever make the alternative argument that the malpractice, the ineffective assistance here was promising the jury the witness without thinking that issue through, as opposed to the failure to call afterwards?
No, he has not made that claim. He has said that it was ineffective for promising him in his opening and then not calling him. And again, the defendant is seen on video entering the bar at approximately 9 p.m., drinking steadily, consuming more than one bottle of champagne. That video was before the jury. We know that he left the bar around midnight after breaking a glass at the place that he was sitting, and we know that that the crash occurs at around 12:15 a.m. We also have evidence. The jury also heard evidence from multiple state troopers, 2 EMTs, and multiple doctors who treated the defendant over the course from the time of the troopers came upon him at the scene of the crash to the time he was transported in the ambulance to the time that he was treated at the hospital, all of whom opined that he was intoxicated. So the evidence of the defendant's intoxication at the time of the crash was overwhelming. And the fact that he may or may not have been drinking between 6 and 9 p.m. was wholly irrelevant. And in a case where the defendant did not call any other witnesses and did not testify himself, it is not a manifestly unreasonable strategic choice to not call one single witness who would stand up, testify to a period of time that is unrelated to the defendant's sobriety at the time of the accident, and then rest his case. That is simply not a manifestly unreasonable strategic choice. So again, it's the Commonwealth's position that the issue of the propriety of the motion judge's order has already been determined. The claim of ineffectiveness is waived and is not properly before the court at this time, but that even if this court were to consider the claim on the merits, it is utterly lacking in merit. It is not a reasonable strategic choice, and it did not, the decision not to call him did not deprive the defendant of a substantial ground of defense. And for those reasons, the Commonwealth requests that this court affirm the defendant's conviction. Unless there are further questions, the Commonwealth is content to rest on its brief.
Seeing no further questions, thank you both for your argument. We'll take a brief recess, 15 minutes, and resume the hearing session at 11:25 with the fourth case.
Thank you, Your Honors.
Thank you, Your Honors. I apologize for the technical difficulties.
Thank you, Ms.
We got by. Thank you. Are we
The
ready?
case is now being live streamed.
All right. The next case on our hearing list this morning is case number 2019 P1316, Ralph Gordon and others versus Greenfield Investors Property Development LLC and another. For the appellants, you may begin.
May it please the court, my name is Tom Lesser. I'm appearing with Michael Alio, and with permission of the court, I would be seated and not standing.
You may.
We're here today on the appeal of a special permit that the Town of Greenfield Planning Board issued to Greenfield Investors Property Development LLC, granting Greenfield Investors permission to build a 135,000 square foot single-use store, commonly known as a big box store. I represent 5 families who abut the property and have opposed the development since the application for a special permit was first filed over 10 years ago. I'm not going to address the long convoluted history unless someone on the court wishes me to do that. What I would plan to do is briefly explain how the Greenfield zoning bylaws give rise to the claims before you, and then address the 2 issues raised in our brief.
I think I have a fairly clear sense of how the bylaw ties together, and including the rules and regulations on large projects of this sort. It seems to me that the central question of this case comes down to a fairly narrow one, and that is the failure of the project as proposed to strictly satisfy one of the design standards having to do with the level of service C preservation at one nearby traffic intersection. And then the dispute between the parties over whether that design standard is a mandatory prerequisite to the authority of the planning board to grant the special permit, or whether the board has some discretion to allow what it considered to be de minimis deviations from that. Is that a fair statement?
Judge, the first issue I plan to bring to the court was the second issue we raised in our brief. I understand that it's at the end of our brief, but I think it's an equally important issue. In retrospect, I should have brought it up as number 1. It's rather straightforward. It has to do with the fact that in granting a special permit, the Greenfield bylaws, the Greenfield ordinance specifically states that the special permit granting authority may issue a special permit for a major development only after finding that the adjacent property will not adversely affect adjacent properties, the neighborhood, the town, or the environment. In other words, without such a finding, a special permit cannot be granted. It was an issue we raised at trial. Indeed, we proved at trial that the development potentially would adversely affect adjacent properties in the neighborhood. The trial court acknowledged it. It specifically found that the neighboring plaintiffs, quote, have put forth credible evidence to substantiate their allegations that they would actually suffer an adverse impact to their property caused by the project.
Wait,
Mr.
sorry.
Lesser, oh, go ahead.
Just to clarify, you're focusing an oral argument on the standing issue? Is that-
No, I'm focusing on a part of the Greenfield zoning bylaws, and we raised it in our brief at page.
Argument number 3 in the brief at page 45.
Argument number 3, which on page 31, we talk about 3 arguments. This is the 3rd argument on page 31 of our brief.
Mr. Lesser, I will confess that when I saw that argument in your brief, I understood why you had it 3rd, because generally speaking, that question is one that is broadly committed to the discretion of the local board, to which we grant very, very wide deference. I mean, you're familiar with the case law in this field on special permits. There's as an appellate court, technically we're not sitting in Boston, but we are nonetheless quite far removed from the local conditions that bear on the local concerns, and that is largely committed in the special permit context to the sound discretion of the local board.
However, the court in this particular case had evidence from 2 appraisers, one on our side and one for the developer, and the court specifically found that both appraisers testified the noise and traffic would adversely affect the value of the residential properties. Both agreed that prospective homeowners do not like to be near heavily trafficked roads. Those were findings of the trial court itself.
But the weight to assign to those particular considerations and the balance in the overall concerns for the community are things that we commit and defer to the board in the exercise of its discretion. I mean, you're familiar, I'm sure, with the very long line of cases along on this principle.
I am familiar with those cases on discretion, but I'm also familiar with the fact that when a specific part of a zoning ordinance says that a special permit cannot be granted until a particular finding is made, and the trial court basically presents evidence which supports our point of view, we wouldn't have been entitled to a review of the evidence by the trial court that's sitting de novo on the issue.
But that's, I guess, why the genesis of my initial question, which was, this is your standing argument, because the statement by the trial court that your clients may have suffered actual harm was in connection with his analysis on standing.
Absolutely, it was.
Okay, and so what you're asking us to do is to say that when one has standing because they may be adversely affected by the project, you win in terms of defeating the special permit. And I'm not aware of any legal authority for us to do such a thing.
The only reason that we would, in general, that's true, Judge. However, it's not true in this case because we have a specific portion of the Greenfield ordinance.
But that provision is common to every special permit ordinance and bylaw, and I think it may even appear in Section 9. I haven't looked at it in a while. But if you go back to Marashlian, 25 years ago, the SJC drew exactly the distinction that Judge Wendland just alluded to.
Well, in this case, what I'm suggesting is where the judge makes potential findings which would have found that it adversely affected the adjacent properties in the neighborhood, we were entitled to an analysis and a review of that issue, which did not occur in this case.
But that is encompassed in the overall evaluation by the board in the exercise of their special permit granting authority. you know, you can contend that that their resolution of that balance was arbitrary and capricious, but that's a tough fight to win.
Correct, but we were entitled to an analysis by the trial court as to whether or not it was in fact arbitrary and capricious, given that the trial court put all this evidence in there.
Well, I mean, we can conduct that review. That's a question of law that we can conduct de novo based on our assessment of whether the board abused its discretion based on the trial judge's findings. But so if you want us to undertake that review, we certainly can.
Yes, I'd like you to do that, Judge.
Okay.
I think that would be appropriate. Now, we did not include the real estate appraiser's testimony before you. It's not part of the record because we thought based on what the judge said, it wasn't necessary.
But once again, as we do that, we're going to be undertaking that review with a very great deference to the prerogative of the local board to be sensitive to local conditions.
Well, I appreciate that, but in fact, there has to be some findings of fact made at the trial level in order to be able to get there. That's what I'm suggesting. And you seem to say, and you're making them at the appellate level.
We're not going to be conducting an independent review of the facts. We have the trial judge's findings in the record. So now we have a little bit of time left to talk about your first argument on the structure of the regulations as they relate to the large project review.
We think it's clear that the trial court found that the regulations in question were discretionary. He specifically stated that it contains flexible language to allow the planning board to exercise its discretion. He then went on to say the court does not construe this section of the bylaw as mandatory in footnote 3 of his decision. And the court stated that, quote, the bylaw provides in part that where such standard is not met, the planning board may, quote, end quote, require the applicant to provide plans for either achieving the desired level of service or maintaining existing conditions. The bylaw does not use the mandatory shall, and the court will not read into the bylaw such mandates. We suggest that was dead wrong.
So our review of that issue is de novo, right? Because that's a legal issue.
That's a legal issue.
All right, so what is your best legal argument that we should construe the bylaw as you say?
The bylaw specifically states for intersections currently functioning at loss C or better, mitigation measures shall be provided.
That's not from the bylaw. That's from the rules and regulations.
Right.
But those design standards are incorporated into the ordinance. But you're reading from 842-4A2.
Right.
And as I read those rules and regulations, the design standards as they relate to traffic, as they relate to municipal utilities and services, and as they relate to the environment, all fall under the general propositions laid out in 842-4, which begins with the following words, that the SPGA may consider the following standards.
And then it goes on to say the layout and design of the project must be consistent
with existing comprehensive plans.
Right.
Okay, but it doesn't.
Adopted by the planning board, we'd say that must is mandatory. Mandatory language, and it's the introductory paragraph is the prefatory paragraph. It seems to introduce but not limited the operative clauses that follow. And I agree with you with regard to utilities and all sorts of other clauses. Those are may clauses, but the ones involving traffic and the ones involving mitigation are shall clauses. And it was wrong for the court to suggest they were may clause. What's a may clause?
Well, I will concede that the structure of a provision that says that the board may consider the following standards and have the first of those standards say that that as a standard the level of service C must be maintained. It's not a model of clarity, but that's where we maybe get a little bit away from the de novo review that Judge Wendland referred to. As you know, there's also a line of cases that say that we are to defer to the reasonable interpretation by an administrative body charged with the enforcement, or in this case, the adoption of their own rules and regulations. So you're asking us to reject the resolution of an apparent conflict between the preamble to this clause and the specific design standards that the planning board adopted.
Well, I think if you actually looked at the decision itself, the decision talks about shall rather than may. I think the judge, in analyzing it, in making his appellate analysis or his trial court analysis of what was before him, simply used the wrong standard. I don't think the planning board had used the wrong standard. It was the trial court, unfortunately, used the wrong standard.
You said you were not going to talk about the convoluted history here, but just out of nothing more than curiosity, I noticed that this case was filed in the Superior Court as an appeal from the grant of the special permit in 2011, and it took something like 6, 7, 8 years before it made its way through the trial court, and now it's in front of us.
It's true, Judge. I just note parenthetically, the developer has been paid over $1 million a year from Stop and Shop, as long as no food stores on that site. So they've been doing quite well. They made their money back a long time ago, and it's gone up. It's been before you once. It was before you once on jurisdictional issues.
Oh, is that right?
And
who remembers these things?
And you ruled in favor of the developer, and then the SJC took further appellate review, and it upheld your decision on jurisdiction. But it said, good gosh, these people deserve a day in court. They deserve their trial. So it remanded it back, and the Greenfield Investors has brought numerous motions for summary judgment, numerous motions on standing. They've all been denied, and eventually we did get a trial.
I suppose this is one of those rare instances where the economics of big box retail remain viable even after these 10 years, if we're talking about grocery shopping.
Well, in terms of 135,000 square feet between you and me, it's probably no longer viable. You know, we probably would have settled for an 80,000 square foot store long ago, which it might be built. But I think that the developer was doing quite well over those years, and also was in no rush to move forward.
Thank you. Unless there are further questions from the panel, we'll hear from the appellees.
Thank you, Judge. Justices.
May it please the court, good morning, Chief Justice and other members of the panel. I am Marshall Centerfit, here today on behalf of Greenfield Investors Property Development. I want to apologize for coming in and out of the screen a few times. I was suffering from every lawyer's Zoom nightmare. My computer was flashing low battery, even though it is plugged in, but I was able to disappear a couple of times and it appears to be charging, so I hope to stay with you. I want to we have thoroughly briefed all of the issues that have been addressed today, all of the issues raised in the plaintiff's appellant's brief. I won't repeat them all for you. I will just highlight a few points, in particular those that have been raised today. With respect to whether there's an adverse impact on the plaintiffs, the only finding in the Superior Court's decision was in fact on standing. It came after voluminous evidence was presented, 4 days of testimony from fact and expert witnesses, and there can be no question that the court considered the impacts, considered the board's review of those impacts. This decision by the board was issued after a 10-month review process that included 10 public hearings, 5 separate deliberation sessions, input from a wide range of constituents, the developer, of course, residents, for and against the project, experts, and included the board's own peer review, traffic and fiscal analysis experts. The Superior Court did not find a particular adverse impact. The Superior Court simply found that plaintiffs did have standing, and I do believe what plaintiff is asking, what the appellant is asking today, is to take that to the logical conclusion to say because the plaintiffs at trial had standing, They therefore must win on the merits. The case law doesn't support that. We've addressed this in our brief. With respect to the primary argument to which the vast majority of the appellant's brief is devoted, the interpretation of Section 842, it is clear that the review standards there are permissive. I would clarify one point, which is I do not believe that there's a contradiction in giving the board the permissive authority to review, consider, and potentially apply certain standards. If you read the provision and think about the specific standards where there are some that say, in this kind of intersection, this shall happen, that gives the board a tool if it's facing a project where it believes that the impacts will be so significant in that particular case that the board can look to its regulations and say, here, we're going to require that this be addressed more specifically. But the board doesn't have to do that. A glaring omission in the plaintiff appellant's brief here also has to do with Section 842. And that is that the prior version of the same regulations had the word shall in the initial paragraph. It said that the planning board shall consider. Plaintiffs attempted on the first day of trial to introduce that prior version as the applicable law. They ultimately abandoned that effort in post-trial briefing, and which we spent significant time on. And so if you look at the legislative history here, in addition to the current express terms that are there, we have a clear circumstance where the prior version was amended to remove shall consider to may consider.
Is that part of our record?
It is, Your Honor. Appendix 2 and 3 are the current version and the prior version. And there's a footnote and other reference in the brief to this history. The other thing I would say about the language, the express language here, and if you look at the very beginning of Section 842, it talks about providing the planning board with sufficient information. So under some projects of a certain size, you don't have to produce all of this information. When you get to a certain size, you have to give the planning board information. And what the very purpose of the entire regulation is to provide the permit granting authority with an information that allows it to do a detailed review. Everything that follows in 842, including the permissive application or consideration of standards, is all about the review of information, which is entirely consistent with both the case law and the practical reality of how zoning decisions are made in this Commonwealth, which is the zoning board of appeals or a planning board, depending on the community, are charged with closely analyzing the facts and situation on the ground. That's what happened here. There is no reasonable reading of the statute that required rigid application of these standards. Importantly, the Superior Court's decision did not turn on an interpretation of a permissive application here. What the Superior Court actually found is that the planning board did consider all of these standards. It applied the standards and that the standards were met. The Superior Court's discussion of whether the language is permissive or not is in fact in a footnote, as appellants point out. And the Superior Court had it right, had the interpretation right, as we've discussed. But the Superior Court went on to say that it has to give deference, and there is clearly a rational basis for the planning board's decision. It went a step further. It said this decision not only has a rational basis, it was carefully considered. There was deliberate effort here. There was significant input. This was the opposite of an arbitrary or capricious process. This process could hardly have been more involved.
Counsel, can I ask a question? Obviously, more deference is due to the planning board on some issues than on others. I think all the parties are in agreement that on the facts, it was up to the judge to find the facts de novo. Yet in the judge's rulings, there's some curious language in multiple areas of it where he seems to suggest he was doing something else. Let me just quote from RA 1-033. He says, I find that there was substantial evidence to support the board's findings with respect to, and he goes on to say what he's finding there, but he's not saying I find these facts. He's saying there is substantial evidence. Is the judge applying the wrong standard?
I don't believe so, Your Honor. The evidence in this case was largely undisputed. For one, there were really no disputes of fact. There were disputes of opinion. There was a discussion about the applicable standards here in Section 842, but the facts were largely agreed upon, which is in part the reason there was summary judgment here. I think what the judge was, go ahead.
Go ahead, no, please.
I was gonna say, I think what my interpretation of the decision is that the judge found that the evidence at trial was entirely consistent with what the planning board had done. And the judge does say at the end, even if he disagreed that the evidence presented at trial should have resulted in denial of the permit, that the deference required and the standard that he is required to apply would show that the evidence did present at least a rational basis. The judge went on to say, in his own review of the facts, in his de novo review of the facts, he agrees with the decision. He points that out on the final page where he says, even if I disagreed, but I do not. So I believe that the judge found de novo facts, heard all of the possible evidence that he could hear, and then applied the correct law. I think he cites the correct cases, applies deference exactly where it should have been. And in fact, I don't believe that in the appellant's brief, they make an argument anywhere to suggest that the board's action was arbitrary and capricious. They reduce their arguments entirely to these two, which they claim are reversible error, one being with respect to the interpretation of the MDR rules and regulations 842, and the other, this issue of noting that plaintiff has standing. I want to afford my brother for the planning board an opportunity to speak. So if there are no other questions, I thank you all for your attention to this matter, and we rest on our brief.
Thank you. For the board.
Thank you, Mr. Chief Justice. May it please the court. Attorney Jesse Belcher-Timmy for the municipal defendants. I don't believe I have anything additional to add at this point after Attorney Centerfit's argument, and I would just rest on the briefs unless there's any questions.
Any thoughts on why the judge said he was applying a substantial evidence standard?
I wouldn't want to speak for Judge Carey. I think he's pretty clear in the decision, though, that he's, I think he outlines the law at the beginning accurately, and I think in his decision, he both, I think he finds facts on his own, and he also grants deference where necessary. I think that he met all the requirements.
And what's the board's position on whether or not its bylaws or regulations are ambiguous with regard to the extent to which someone could not meet a level of service and still get approved?
Well, I guess the board's position, the only board's position that's involved here is the actual resulting decision. The board certainly considered all of those factors. I think they also were aware of the May language that discusses all of the standards and the design review standards. So I think that, as Judge Carey found, I think that both the planning board's position would be that they had discretion to consider those things if they needed to, but also that they did and sufficiently found that the project complied with those standards.
Anything further?
No, thank you.
That will conclude the argument in this case. We will conclude our hearing session this morning with the final case, which we will call in a moment. Thank you.
Thank you.
If the court is inclined to or enter any decision that's actually dispositive or that it reaches this or is inclined to, I would ask, oops, I just started hearing myself.
All right, the case is live streaming.
Oh,
All
okay.
right. We now reach the fifth and final case on our hearing list this morning. This is case number 20P18. This is an impounded matter. It involves a termination of parental rights, and I will remind counsel again to refrain from to any proper names or any other impounded material that ought not to be podcast to the public airways. Okay, you may begin.
Thank you, Chief Justice. May it please the court, Kara Chayette for the child appellant. This case at its heart raises a question of the sufficiency of the evidence. And when an appellant raises or challenges the sufficiency of the evidence, the question before the court isn't whether the findings support the ultimate, the subsidiary or preliminary facts support the ultimate finding of unfitness. The question is whether the evidence supports those findings that are then folded into that ultimate finding of unfitness. And
Counsel, can I stop you there?
Yeah.
I'm a little confused about these issues with respect to your client. Your client not only did not appeal herself, but the position of your client at the trial was that the mother was not currently fit to assume custody of your client. Your client did not want the mother's rights terminated in order that the mother might be able to show her continued sobriety and eventually regain custody. It seems that your client got everything she was seeking, including now reunification. So it's very confusing to me to see how you're challenging determination of unfitness when your client's own position was she didn't want to go back with the mother at the conclusion of the trial.
Well, first of all, I filed a supplemental appendix because my client did appeal. She filed notices of appeal from all underlying orders, from the court's denial of the mother's motion to reopen the evidence and the denial of additional visitation and the underlying decree. Those are in, and I do not have my record appendix, but there is a supplemental appendix because my notices of appeal did not appear in the mother's appendix. That mother took the principal responsibility, and I can quickly actually get to that if you'd like, and just tell you what. So the record appendix of the child appellant, which is I've turned off all of my other Wi-Fi devices to make sure I had the best Zoom. But it is actually, I bet you it's right in my procedural history. And I'm sorry that I didn't have this right at my fingertips. Alana, excuse me. She timely appealed both of the court's orders and they appear at the record appendix 71 and 72. I was reading from my brief, I apologize. Never done that before. But with respect to what she said to the judge, she did say, maybe give my mom a few more months. She's been doing really well. My client testified it was November, December of 2018. And she said, maybe at the start of the summer, I could go back to her, but I'd like more visits. I'd like at least twice a month visits. I'm only getting once a month visits. And so was she pressed for, should she go back now? She was trying to be reasonable, I think. But she said, yeah, I want to be with my mom and let's give her a few more months. But I have every confidence that she's going to be doing fine. This question about the current reunification, again, goes to this question of the mootness. And I'm not sure if I should take that on. We had that discussion, but I don't think that renders any of this moot.
Okay, well, let's talk about the specific findings the judge made and whether or not they have any impact on your client, given the current posture. I understand you're arguing in part that the subsidiary findings do not add up to clear and convincing evidence of unfitness. But you also at least say you're challenging some of the subsidiary findings as clearly erroneous. And I'm having a hard time figuring out what those subsidiary findings are that you're saying are clearly erroneous, and why, and what their continued viability are in terms of impacts on your client.
So the judge entirely dismissed my client's testimony about her ongoing relationship with her mother for the 4 years prior as a product of her mother's manipulation. So the judge found that my client and her mother had seen each other twice from 2014 to 2017, and that my client refused completely to see her mother during her mother's year-long incarceration in the House of Correction, which footnote was for shoplifting. I mean, we're not talking about violent crimes. But the evidence shows the reason why the judge wasn't aware that they had this ongoing relationship, yes, with periods of no contact because her mother was struggling with her recently acquired addiction. But the DCF records, to the extent they captured this, because DCF wasn't involved with my client and her mother. The CNP had closed in 2014. My client was with her father. So to the extent that DCF got involved at all, it was because of the father's difficulty parenting the kids. And over the years, and I'm sorry about that, over the years that she was with her father, there would be times when DCF's records say, you know, she was regularly seeing her mother, they had weeknight visits or weekend visits, the father didn't report any difficulty. There were moments when my client said something like, my mother's dead to me. And the judge took those statements of a feeling, of a current legitimate feeling, and said that captures the relationship. They didn't have any contact. The client refused to see her mom. Those are absolutely wrong in this notion that her mother manipulated her and should have been.
Yeah, but at least with respect to your client's testimony, the judge was free to reject that as non-credible, correct?
But it's the court's obligation to see whether that selective credibility determination is reasonable under the circumstances. So where DCF records have statements throughout about ongoing contact, then the judge could, yes, dismiss my client's testimony, but then the judge has to find some other evidence elsewhere in the record to find that the opposite was true. And where the record evidence supports what the mom said about their ongoing contact, supports what my client said about their ongoing contact, then it's an abuse of discretion for the court to find that they had no contact and they're both uncredible. And this whole issue about the mother supposedly manipulating the daughter out of the home multiple times, the judge even said on the record at trial, there's zero evidence that this happened more than once.
Let me pause for a moment, though, and ask about how this bears on your claim of regarding mootness.
Because going forward, in 2014, the first CNP closed. DCF gets back involved. They reopen the CNP in 2017. And what is it that you see in the record, and what are the appellees going to argue? They're going to be arguing about events in 2013 and 2014. And the findings that we have now will have gotten fixed in stone. And so in perpetuity, any future involvement with DCF is going to rely on these, what I claim are wildly erroneous findings. And I see you.
How old is your client?
She's 15 now. And there were a set of findings and facts from a 6-month prior trial involving 2 different children. Those had not yet been tested on appeal. Those were admitted at trial in this case as Exhibit 76. And the judge cited those 34 times and took those.
Tell me if I'm wrong, those were admitted by agreement, or at least no objection.
There was no objection, but the basis, and yes, absolutely. But bear in mind that the reason why what happened at the prior trial became an issue here was that in order to be efficient, mother's counsel, who was bringing the expert witness, said he just testified 6 months ago for like 75 pages worth. I'm going to endeavor not to repeat, and the judge certainly is going to appreciate that. And so it was after that that she was trying to be narrow and offer the transcript of his prior testimony that DCF late in the day said, if you're going to admit the transcript, admit the findings. And yes, at that point, there was no objection, but it's still not, I don't think it's a non-issue, at least with respect to the mootness of these findings going forward. And if my client ever has DCF involved in her life as a child or as a parent, if DCF gets involved, these findings, if they're not correct, as I argue so many of them are, the way they characterize my client and her mother and the relationship, that can in very real ways come back to haunt her if she ever decides to be a foster parent.
But we are looking at on appeal, we are looking at whether the decree may stand. We are not going to conduct a de novo review of the record and enter new findings.
I understand that, but Your Honor, isn't appellate review, if I had not challenged any of the findings or the evidence, then I understand that. But to say that it's not the court's obligation to at least parachute into the record and see whether this is what you see in the findings is the needle pulled out of the haystack, and not representative of the hay. That's an insufficiency argument. It distorts and mutilates the actual evidence. It's not just, and I know the court just issued Cruz yesterday and sort of dealt with some of these issues, but there's really, certainly with the expert, and I know I'm a little bit over my time, but with Friedman, what the judge did, the Friedman was the expert, sort of took some of what he said out of context, credited those things that she was that supported her determination, and rejected wholesale everything else. If you only look at the findings, it does sound like this guy met with mom for a few minutes and looked at a few records. He had met with her for a long time, checked her records, confirmed that what she said was supported by the records, and grounded what he said about her prognosis in research, in his practice, in talking with her, and in facts about the mother.
I think we're going to have to leave it there. Thank you.
Thank you very much for your time.
For the mother?
Please the court, Adriana Condortesi for the respondent appellant mother. The argument that mother takes the greatest interest in starts at page 25 of my brief, and that goes to the post-trial motion to reopen the evidence. The judge did write a meaningful decision on why she chose to deny the motion to reopen the evidence. But mother still contends that evidentiary hearing should have been held for a few reasons. First of all, she was entitled to it pursuant to section 26 because this motion was filed 5 days prior to the issuance ultimately of the adjudication of the termination as to the 10-year-old child, the younger child. And secondly, the evidence was really important. A DCF had seen fit to return 2 children back into mother's house, not with mother as the custodial parent, but as the guardian of her new husband's 2 children who were close in age to the 10-year-old and the 16-year-old as well. So there were lots of reasons why the evidence was compelling. Not only that, but there was DCF personnel in the building who was ready to testify to these different things.
Counsel, just a fine point, but what is the current status of the care and protection matter involving the other 2 children? I don't mean the husband's children. I mean the children of both the mother and her husband.
Judge, I'm only familiar with the status of the 10-year-old child that mother is appealing the decision from the termination. And as to the other children, I'm not sure I'm following you, but I bet Attorney Salcedo will know.
Okay.
And I can give you a better answer, Judge.
Okay, good. Especially since time is short, can we kind of cut to the chase? And I want to ask, the younger child here who just turned 10 was last living with the mother when he was 2. By my count, he's been living with the current foster family for almost 3 years. They are prepared to adopt him. He is thriving in that environment, partly because they're attentive to his special need. The mother has had some visitation with him. The judge found no bond similar to the older child. How does it make sense to send this child back to mother at this point in time?
If we had the evidentiary hearing, I would be able to give a better answer to that, Judge, either way. And that is the real point of my brief, that the case should be remanded so that that evidentiary hearing can be held. We know that there's biologically related children to the 10-year-old boy now living in mother's house, and children that he knows and has attachments to. The evidentiary hearing should have been held. I don't know which way it would go. These kinds of cases are very difficult. I know mother had her ups and downs, and she acknowledged her culpability to these events at trial. She was very candid. But at the end, DCF did find her.
But it's not an unusual counsel appears to be frozen.
Yeah. Oh, she's back.
Okay. Well, what I was going to say is it's not an unusual circumstance in these cases where the parent is saying, I'm starting to get my life turned around. I need more time to show that. That happens in a majority of these cases, frankly. And the case law is clear that at some point, the trial judge gets to say, enough is enough. Even with the pending motion in front of the judge, why didn't the judge have discretion to make that call at this time?
Judge, I'm not saying that the mother did not have discretion. And in fact, if you construe the request for the evidentiary hearing as a request for review and redetermination pursuant to section 26, you can't say that, I mean, while mother would have been eligible for that hearing, she wasn't necessarily entitled to it without question. So the judge did have discretion, and the mother is aware of all these problems. But the liberty interest of those biological ties is so great that, perhaps the judge did abuse her discretion in denying to hear this new evidence. And there's I don't think, despite all the things that His Honor brings to my attention, and I certainly can't argue with any of those, but I don't think anybody could argue with the idea that it's pretty big news when DCF suddenly decides to place 2 children in a home where almost simultaneously the judge has found is a place where a mother who is unfit to parent the 10-year-old lives.
All right.
So it's a big evidence. It was big evidence that warranted to carry out the evidentiary hearing.
Thank you.
Thank you.
We'll hear from the department and the other child. In what order will you be arguing?
Department first, Your Honor, and I'll be splitting my time with counsel for the child, for the younger child.
Yeah. You may proceed.
May it please the court, Richard Salcedo for the Department of Children and Families. Just first start, follow up, if I might, with Justice Milkey's several of the points he made with regard to the younger child. The court specifically found, because of the parental neglect that he had been exposed to while in the care of, in mother's care, and also subsequently in the care of his father, that he suffered the after effects of that neglect, and that he has particular special needs, behavioral and emotional needs, and that those needs are currently being met in the care of his pre-adoptive parents, where he has continuously resided since 2017. The evidence in this case, also another point that I wanted to clarify, the two children that were placed in mother's home are not related to this child. The two children who were placed are the current husband's children from another relationship, and there's also no evidence that he has any attachment to these children that I'm aware of in this record. And so the court's decision to terminate mother's rights as to the 10-year-old child is supported by the evidence in this case. With regard to the motion to reopen the evidence, the court, as counsel mentioned, wrote a meaningful decision addressing the proffered evidence, the evidence being that mother had an additional period of sobriety and that the two other children were being placed with her. But the court correctly noted that the fact that the two other children who were not parented by this mother, not related to this mother, she has no history with them, and that that the court had considered extensive evidence over a 4-day trial, specifically related to regarding mother's parenting of these particular children, and in light of these particular children's, the subject children of this appeal, in light of their particular needs and their histories. The court, in its decision, which is part of the record, gives sound reasons for denying the motion to reopen evidence.
Now, counsel, as you know, the motion to reopen the trial record was filed before the decree was issued. It was 3 or 5 days. Shouldn't the judge more properly have considered this issue before issuing the decree?
Well, I think the court did. There was a hearing before if I'm not mistaken, before the court issued the decree. The written decision came out afterwards, but the motion was denied. There was a hearing on the mother's motion, and the court did properly consider that evidence and concluded correctly, I believe, that it would not have changed the outcome of the case.
Now just say he considered the evidence, you mean just attorney argument, right? There was no testimony from any of the witnesses that were sitting there ready to go forward.
That's correct, Your Honor, I believe, yes.
He considered on the basis of a proffer.
Correct.
Now, please tell me if I'm completely confused, but aren't there two other children?
Yes, so mother parented the two subject children until earlier in their life, until 2013. After that, mother would go on to have 2 children with her current husband. Those 2 children became a subject of a separate C&P
and what's
after
the
mother
status of that?
overdosed. So both her and her current husband's rights to those 2 children were terminated.
And is that on appeal?
No, not as far as I know.
What's the department's position on whether or not this case is fully moot with regard to the older child?
I would say that it is moot at this point. I also I would argue and argued in my brief, and my sister, the counsel for the appellee child, also that there was sufficient evidence of mother's unfitness that was presented at the time of trial. So the trial court's finding of unfitness as to the older child was supported by the record in this case.
But
that was
if
presented at the time of trial.
If the case as to the older child has now been dismissed, and the appeal by virtue of that dismissal is moot, those findings are not final, right? There's been no final judgment. If the decree is vacated, they would not be available for issue or claim issue preclusion on collateral estoppel or any other basis in the future, because the dismissal of the petition and the vacation of the decree would wipe it away. Isn't that the case?
I'm not sure, Your Honor. I would guess that it.
If we decline to consider the challenges to the basis for that on grounds of mootness, they have not become final. They have not gone to final determination with a full review. I'm not sure how they would be the basis for future dispositive effect.
I believe that is probably correct, Your Honor. Yes.
And does the department have a view on how the judge can dismiss the C&P petition while the decree has not been modified or vacated?
Yeah, I'm not clear on that, Your Honor. I was not even aware that this action had been taken until counsel had notified the court that the C&P had in fact been dismissed. So I'm not actually prepared to argue that point about whether the trial court had jurisdiction or authority to do that.
Well, but it was the department. The department participated in that request, right?
I would imagine so, Your Honor. I don't know. I was not.
I mean, I've read the docket, the updated docket, and it appears that the department initially opposed it and then came around and agreed to it. Is that consistent with your understanding?
I'm not clear, Your Honor. I could notify the court and clarify the information about what transpired in the trial court and what position the department took with regard to the dismissal.
Well, I mean, the docket reflects that the department joined it, and it's a little disappointing. This is the status report has been in front of us for a little while. I mean, I guess, Mr. Salcedo, I'm disappointed that you haven't consulted with your client to determine what their position is, because that leaves you, I suppose, ill-equipped to answer my next question, which is whether the department would agree to stipulating to an entry of an order vacating the decree as to the older child in the lower court.
Well, I believe that we probably I would have to consult with my client, and I could let the court know.
Let me frame it a different way. If the department agreed to the dismissal of the C&P, would the department then agree to entry of an order vacating so much of the decree as relates to the older child?
I would imagine so, Your Honor, but again, I would have to confirm that, Your Honor. I'm sorry.
There are things that we can do to cure any technical jurisdictional defect that may arise by virtue of the fact that the juvenile court acted on a pending decree while it was subject to appeal without seeking leave of the appellate court. But it would be helpful to know what the facts, not just on the ground, are, but what the position of the department is vis-a-vis the other portion of the action.
Your Honor.
When can you advise us on the answers to those questions?
Very soon, next week, I could advise, Your Honor.
By 1 week from today?
Yes.
Okay. Sooner would be better, I suppose. But we'll appreciate that update. Okay. I don't have any other questions.
Okay.
Anything more to say, Russ?
Well, unless there are any other questions, I'll just yield the remainder of my time and yield
Could I just ask for a quick response on the, you heard your sister argue that DCF records reflect more visits between the mother and her daughter than the judge found. And she argues that there was no evidence to support, no affirmative evidence to support the judge's finding that only a limited number took place. How do you respond to that?
There clear evidence in the record that it's a court investigator's report from 2017 that the child only saw the mother 2 times during the intervening years when she was in father's custody. And father, she had indicated herself that father shut off any contact, and she had mentioned to the court investigator's report, court investigator, that mother was dead to me. During that period of time, also mother was incarcerated several times, including 1 year before the trial began in this case, and had no contact with her during the time she was incarcerated. So I think that there is support for the court's finding that the child had minimal contact with the child during that period of time. Unless there are any other questions, rest on my brief for the remaining arguments.
All right, let's hear from the counsel for the younger child.
Thank you, Your Honor. Susan Taylor for the younger child. May it please the court. On behalf of the younger child, I would be asking the court to affirm the judge's decision to terminate the parental rights in this case. She did not abuse her discretion when she found that this mother lacked the ability, capacity, fitness, and readiness to assume the parental responsibility of caring for my client. As Judge Milkey had noted, my client will be 10 in about 10 days. He has not resided with his mother since he was 2. He was removed. During the period of time that he lived with his mother, she was abusing opiates. She was living with other people who were abusing opiates. She allowed those people to care for her children while she used drugs. And I think it's important to note that in this case, the evidence, the question is really whether or not the evidence was clear and convincing. I would tell the court that I think that it was, and it's uncontroverted. Mother does not stand before the court today saying that the findings of the factual findings of the judge were wrong. At the time that my client was removed, he was 2 years old. He then was in foster care for 9 months following his removal. And it was only a year later, the following year, when the father took custody and the mother admitted that she was unfit to care for the children. She stipulated to that. My client was then in the care of his father, who was unable to meet his needs. And those children were removed when my client was 6. Since that time, I should note that between the time that he was removed, he was in 12 different foster homes. He was moved in night-to-night placements. So now he is currently placed in a pre-adoptive home that has been able to provide the care and support for the educational and special needs that he has, which are really the direct result of the lack of care that was provided by his parents. This appeal is really inviting the court to reweigh and reconsider the factual findings of the judge and her ultimate decision that this mother was unfit and that the parental rights should be terminated. But I would suggest to the court that at this point in time, the mother has not contested those facts. So acting on those facts, I think that the appellant has not shown that the judge abused her discretion in reaching that conclusion.
Well, counsel, the biggest debate, if you will, at trial was whether mother would be able to turn her life around. And she was off at least the hard drugs for going on a year by the time of trial. And then the question is she going to have another relapse? Turning to the motion to reopen the evidence, why isn't the fact that the department blessed these two children, the husband's children, going back to that household, at least some robust evidence that the mother had turned her life around?
Well, at least with regard to the motion, I think what the judge says in her decision is the fact that DCF has decided to return two children who are unrelated to mother into the home wouldn't have changed my mind. I think that's the sum and substance of her decision, that I understand that two children who are the husband's children have been returned, but that wouldn't change my mind on my decision. So, because at the end of the day, this particular mother, from the time that my child was removed from the home, she had two additional children. Those two children were removed when she repeatedly used drugs, relapsed, overdosed, and those children were removed, and her rights to those two children were terminated. Those are two children that she has with her current husband. So I would suggest that the judge was well aware of what the additional evidence. I don't know that an evidentiary hearing would have changed anything. She knew that the evidence that the parties were seeking to, that the mother was seeking to admit, was that two children had been returned. I actually suggested it probably would have been a little more compelling if the two children that were returned were her own children, but it isn't that. And at this point in time, my client has the right to some closure on this. He has waited a year since this decision in limbo. I would suggest there is no evidence and that the judge abused her discretion in terminating the rights as to him. And if you really look at the mother's actions from his removal at age 2 to now, it's been a pattern that this judge noted in her decision, is that she has this pattern. She goes into rehab, she gets better, she relapses, she gets incarcerated. Well, that's really a prognosticator for what's going to happen in the future. My client's waited 8 years for her to get her act together. She hasn't done it. And I would ask the court to affirm the judge's ruling. And I see I have 37 seconds left. I would, unless the panel
you're unmute.
You have nothing more to say to us in those 25 seconds. And seeing no further questions from the panel, I we'll conclude that the argument in this case is complete. The case is submitted, and that will conclude our argument session this morning. Thank you all.
Thank you.
Thank you.